Thank you very much, and hello to everybody. I think I'll start with two pictures. I come from Attac, been with Attac from the beginning. I've been working on trade issues since 1994. I've been living in Africa and worked with African civil society, government researchers and others in order to strengthen African positions in the World Trade Organization negotiations. I want to share two pictures with you. And one is in '97. There was a conference arranged by Médecins Sans Frontières in Switzerland, and there was one of the traditional healers from Zimbabwe, which were present there, Dr. Shizike. What happened while we were in this meeting? They had for a long time cooperation with pharmaceutical industry and researchers at the University of Lausanne. And what happened was that he suddenly had become aware that the cooperation that the traditional healers had on their knowledge and the biological resources they used for medicines in their own country suddenly was patented by these researchers that they worked with in University of Lausanne. So it's not only a question of how transfer of technology and knowledge can be done to the south, but also how it can be prevented that technology and knowledge from the south goes to the north through the patents. And the development of regulations on that issue, which is under the UN Convention on Biodiversity, is not moving. The other picture, and your company, Roland, was a part of that, was in South Africa, where South Africa actually in late 90s had changed their legislation to the patent legislation, which quite much looked like the American legislation, meaning that they had made access to compulsory license, tvangslisensiere medicines, and also to import parallel from other countries that had cheaper production, for example India, or that had cheaper medicines in the markets, for example Kenya. So they had made such a regulation in order to be able to increase the amount of people that had access to HIV/AIDS medicines. At that time, two things happened. It was end 90s, meaning that the time where it was time to renegotiate, review the TRIPS agreement in the WTO under the current agreements was nearing. But what happened was there was no country that brought South Africa in for the World Trade Organization disputes agreement. But Glaxo Wellcome at that time brought took to the court, to the National Court of South Africa, that legislation in order for South Africa to not use their right under the TRIPS agreement to offer access to medicine. The US did not bring this towards the World Trade Organization, but what they did, they put simply South Africa on the list of those countries that they did not advise investors to go into because they did not accept the private property of investors. The legislation was quite equal to the American legislation. So that was two ways of dealing with it. Unfortunately, it did not happen. Glaxo Wellcome at that time withdraw the case from the court, and South Africa, after a time, promised not to use the legislation. At the same time, Bill Gates created his fund for buy up cheap medicines for poor people in Africa and in the developing world. And that was interesting because that released the pressure on that review on the TRIPS agreement in the World Trade Organization. So it's interesting to see who has benefited the most in the world of the patent legislation. I won't exclude Bill Gates from that one. So that is reality. And then the issue, why wasn't South Africa at that time brought in for World Trade Organization dispute? And why did not Glaxo Wellcome at that time complete the court case in South Africa? There are on patents, and I want to say I won't say against any patent. I'm not saying that's not the reason. But what is happening now is that today we have usually had the different sort of patents that can be given, and for food and genetic biological resources, and for medicines, there had been a certain exclusion to patents from the very beginning and until the conclusion of the World Trade Organization. That exclusion was that you could patent a process, how to make a certain medicine, but not the product itself. Meaning that another producer could find another way to that product. It could be food, it could be medicine. So that the process could be patented, but not the product. Meaning, you could find another way, you could produce the same product and end up with a sort of competition in this phase. So, in terms of those very, as was brought up by Michael here, is it legitimate to set rights over profits? And in terms of that, this was a way actually to do it, and that is what India had used in their legislation, to actually not give product patents, but that is something which is under challenge. But then a new innovation on the patent is in way, and it's right what is said here. The US is the most pushy on trade and changing the TRIPS rules. And that is the issue of information related to a medicine or to a patent. So that, for example, all the testing could be now kept as a monopoly. So that the information of how to produce a product and the reaction, all the effects of by-effects of for example, a medicine, now should be patented, so that should not now be available for producers after the patent has run out. The patent runs for 20 years. So this is something that is now a huge battle about, not in the World Trade Organization because it's not that much, but in the World Intellectual Property Organization, WIPO, which is also situated in Geneva. What the patent treaty gives, in addition to 20 years of monopoly of both product and process, is a monopoly for that time, but not only a monopoly, but a discriminating monopoly. That means that the producer, the patent holder, can decide who to import a product. That means that they can not only decide a sort of the global price for their products, but they can decide how much is the maximum profit they can get out of South Africa. How much is it's called discriminating monopoly, meaning that you can have a higher price in South Africa because there are so many poor people that to give the same price as in Kenya or as in India doesn't really mean anything, because they will get maximum profit of having a higher price, because it's in any case it's only a certain amount of percentage of people which has the access. So this is some of the areas where it makes it difficult, because there are exemptions in the patent treaty. I would say exemptions as they were interpreted by the US. Make it relatively good framework. It's a question of power who can use it, as the South Africa case showed. And that is if you declare a state of emergency, then you can actually compulsory license a project as US threatened to do when they had this anthrax medicine. They threatened immediately. You know, it's only three people had been attacked by this illness. Declared it state of emergency. Now we are gonna, if we are not getting cheap medicines now, we are gonna compulsory license. And it's also possible to do a parallel import if it's cheaper in a country because of this discriminating monopoly. Then you can import from this place. So, what was agreed in the World Trade Organization? Originally, when the TRIPS came into the World Trade Organization, it came late in negotiation process. It had been 7 years of negotiations, and in 2003, 2004, suddenly a fully designed patent treaty came into the negotiations, and developing countries was very much against it. They say this will not give ability for us to copy knowledge. It will reduce our access to essential medicines and food. It will expropriate our knowledge and our resources, especially biological resources, and it will prevent technology transfer in the way that the industrialized country have been using. I don't know if any of you is aware, but in the industrialization process in Norway, we actually had industrial spies on public budgets in order to go to Germany and other places to copy and reverse engineer when they came back. This does the trip not provide for. So what happened is that after these what happened is that developing countries say, okay, if we can review the TRIPS agreement, they had exemptions for 5 years. If we can review the TRIPS agreement after 5 years, it'll be okay. What happened after the 5 years was first we had the Seattle ministerial meeting that collapsed. The one in Doha in Qatar in 2001 actually now accepted. Not the review, but the interpretation of the US it was not a review of the agreement, but review of the implementation of the TRIPS agreement. That's a very different thing. Yeah. Norway accepted that at that time. The Soria Moria Declaration today has accepted developing countries' approach to a TRIPS review. So that's at least public policies, and reports we get from the South is that it is followed up. What I do want to raise as an issue here is that it's not just a question of making medicines cheap. It's also a question of making more countries able to produce medicines. In the SADC countries, Southern African Development Community, which consists of Southern African countries, they have made a program for that. How to make production capacity in the country. They have a strong idea on research, on how to deal with it, how to have a legislation, and a draft model legislation for the countries, and a vision linked to knowledge, research, and employment. And access so that they will not get negative balance of payments and balance of trade because they need to import these highly costly value-added products. So this is something which the SADC have created for 2005, and there are also other initiatives which has come. For example, Brazil, which has quite a lot of skills, Angola that has quite a lot of funds, and Mozambique that is a least developed country and have still exemption from the patent treaty. That these Portuguese-speaking countries could work together in order to produce a company in Mozambique to create medicines, and that could be a part of, for example, that SADC vision. So for them to think on production is very important. I just want to say, finally, it's interesting that from 2000 and when was it, when Glaxo-Wellcome sued the Africans, the South African state?
99 or 2000.
99, 2000, and until today, you know, that focus that Medicines Sans Frontières, what civil society in these countries have done, it is capitalistic companies, and they want to make monopolies as far as they can. You know, it's just to understand. So what is the reality is that we, of course, need to challenge how they deal with it, how they sue and undermine political attempts in various countries, and to make policies that in case we don't want to pay for public research, for public production as sort of public service and production, then we need to have a strong control of these companies, especially when they are monopolizing as much as they are, both in terms of production and in terms of mergers. So that's